So thank you for checking out SNU's Contract Bank. I'm Roxanne Smithers, co-founder of Smithers and Umewabo. So this video is going to provide a brief overview of our Master Marketing Consultant Services Agreement. So the Master Marketing Consulting Services Agreement is a bit self-explanatory. This agreement is for professionals who are providing marketing consulting services. So that can be a range of specific service types that you're providing where you're supporting your business owners in their marketing efforts. Whether that's digital marketing, whether that's television, radio, events, or other types of marketing. If your business is focused on supporting your clients' efforts to get their name out there or to publicize their services or goods or product, then this marketing consulting agreement would be for you. It's referred to as a master agreement because you have the opportunity to utilize this agreement not only with multiple clients and business owners, but with repeated engagements with the same business owner. You do not have to have a client sign a new contract every time they come to you for services. You can simply utilize the scope of work feature at the end of the agreement and issue a new scope of work for every new project that you work on with your client, knowing that the parties have already come to terms for your services. And you can make modifications in that scope of work as necessary based upon the term, payment structure, and other incentives that may be involved. So as we take a quick look through the marketing agreement, we are going to cover one of the most important things, which are fees and expenses. You want to make sure that you have a clear understanding with your clients in terms of how much you're going to be paid, how you're going to be paid, and whether or not you're going to be reimbursed for any expenses that you incur on their behalf. Maybe paying for vendors, maybe registering websites, or paying for online ads or analytics. The agreement then gives you an opportunity to make any modifications down the road. Consider that you guys decide that you want to change your fee structure, or you want to change the term of the agreement or other terms within the document. This provision lays out how those changes will happen. Most often they'll happen in that scope of work. We then have a paragraph that gives you some general information about your services and your responsibilities as the consultant. Some of those specifics are then going to be laid out again in that scope of work. But we are providing time and information for clients to provide input on your work, give you approvals for that input so that you can move forward with your services. We also have a paragraph in section 5 that lays out the responsibilities of your client. We all know that with any good service provider, part of the success of your business and your services is the cooperation of your clients, making sure they provide accurate information, that they provide timely information, and that they give you approvals when necessary. And so paragraphs 5 and 6 cover both the client's responsibilities as well as a process for clients to approve any deliverables that you are creating for their benefit. Paragraph 7 details the intellectual property rights. This means who owns the creative results of your work or pieces of creative property that are brought to the table for you to utilize while providing services. So the intellectual property provision lays out who owns the rights to that intellectual property while you're working on a project and creating materials for your client, and who owns that material after your client has paid. And those can be very different because many times for creatives, some of your leverage comes in owning the intellectual property until the point of payment. Paragraph 8 lays out any representations or promises that you're making with regards to both the quality of the work that you're providing as well as the results that are coming from your work. We include a limitation on warranties, which essentially means that you are letting your client know that you cannot guarantee a specific outcome, a specific engagement, or a specific maybe revenue stream from your efforts, but that you are going to put forth a good faith effort and do a good job. Paragraph 9 covers how do we handle confidential information that your client may provide to you or that you may share with your client. Both parties are going to be required to protect that information and to honor the confidential nature of that information. Paragraph 10 protects your employees, your staff, and some of your other resources or vendors from your client soliciting to work with them directly without your permission. Paragraph 11 details how long the contract is for, how it will renew, and how the parties can terminate the contract if they decide to not move forward with the business relationship any longer. Because this is a master agreement, you can terminate specific scopes of work or you can terminate the whole agreement overall. Paragraph 12 is the limitations of liability. This paragraph simply puts a cap on the amount or the ways in which you may be liable if your client has any dissatisfaction with your services or there are any unforeseen incidents that occur that may create legal or financial claims or damages. Paragraph 13 covers indemnification. Indemnification is simply a fancy legal term for one party is going to be responsible for any losses, damages, or claims that are suffered by the other party, and that you will step into that party's shoes to resolve those claims or those issues. In this document, we have provided a mutual indemnity provision, meaning if either you or your client causes a problem or works in a way that results in a loss or damage or claim to the other party, that you'll be responsible for resolving that claim or that damage, with that cap on limitations of liability in mind that we discussed in paragraph 12. Paragraph 14 and 15 make it clear that the parties are free to provide their services and to solicit services from other parties as well. This is not an exclusive agreement. You are not an employee of your client, and your client is not authorized to make legal decisions that are binding on you. Paragraph 16 covers the law that will govern your dispute. Wherever you and your business are located, the law of that state will cover your dispute. For example, if you are a business located in Georgia and practicing in Georgia, then Georgia law will cover your contract. Paragraph 17 covers how the parties are supposed to handle a dispute. In this paragraph, we provide an opportunity for the parties to negotiate a resolution, if not, to mediate a resolution, and if they are unable to come to terms that way, to arbitrate their dispute. Of course, the parties can always agree to other dispute resolution procedures, but we think it's important to have a framework in the agreement. This paragraph also states that whichever party is successful in the dispute will have an opportunity to recoup their legal fees. Paragraph 18 details how the parties are supposed to give each other notice of any changes that they would like to make or any activities involving their performance under the contract. Paragraphs 19 and 20 deal with how the contract will be interpreted if there is a dispute. And paragraph 20 deals with if in the rare occasion that a court determines that any section of the agreement is not enforceable under that state's laws, that the remainder of the agreement will stay in place. Finally, paragraph 21 explains how the parties can modify the agreement and lays out that any prior oral communications that the parties have had or communications and terms that were agreed to that are not detailed in this agreement will not bind the parties. At the end of the contract, you will find your statement of work. This will detail the specific scope of work that you are agreeing to handle for your client, any specific deliverables that are part of the work of the project, the specific time frame for your performance, as well as how you will be compensated. The agreement provides for hourly compensation, flat fee compensation, retainer compensation, or a percentage deposit for the services. The statement of work also gives you an opportunity to request and require a retainer amount upfront before you provide services to your customer or your client. It allows you to detail any anticipated expenses, and it also allows you to put into the agreement what your rate is for any work that is outside of the agreed upon scope. So this is the Master Marketing Consultant Services Agreement. As we've previously stated, if you purchase this agreement, you will get a PDF copy as well as an editable version of the agreement that will allow you to make modifications as necessary for your specific engagements with your customers. So this is Roxanne Smithers with SNU's Contract Bank.